Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Okay, let's unpack this. Today, we're diving deep into a topic that is, well, absolutely crucial for any founder, innovator, or aspiring entrepreneur out there: intellectual property, IP.
Right.
Especially for startups.
Right.
In today's, incredibly competitive and rapidly evolving ecosystem, understanding IP isn't just some legal nicety. It can genuinely mean the difference between safeguarding your groundbreaking ideas and, well, inadvertently losing your competitive edge.
Totally. It's fundamental.
Think of it as the invisible shield around your brilliant breakthroughs, or maybe even the fuel powering your rocket ship.
Good analogy.
This deep dive is all about getting you well-informed quickly on this complex but utterly vital subject. We're going to journey from the fundamental definitions of what IP actually is through strategic applications and the clever ways to use it, the common pitfalls to absolutely avoid, and even peer into the future trends that are reshaping the whole IP landscape.
You have to move it fast.
It's really a mission to transform those intangible ideas into, enduring competitive advantages.
And what's fascinating here is that for many startups, IP isn't just legal jargon or some box to tick. It truly underpins much of the value-driven innovation that, defines success in the modern economy.
Right. It's the core value sometimes.
Exactly. For companies built on novel ideas, proprietary techs, or unique brands, their intellectual property often constitutes their most significant asset, often far outweighing the tangible ones like desks and chairs.
Yeah, laptops don't compare.
Not really. So our mission today is to provide a comprehensive guide, extracting the most important insights on IP rights, strategic protection, leveraging that IP for growth, and crucially helping you avoid critical and often very costly mistakes.
Okay.
The ultimate goal is to help you transform those intangible ideas, those creations of the mind, into enduring competitive advantages, really unlocking your full potential in the market.
So when we talk about intellectual property, what exactly are we defining? I mean, where do we even begin to grasp its very nature? It sounds so broad.
It does, but at its core, intellectual property, or IP, refers to creations of the mind. And that's not just a poetic phrase. It really encompasses a wide array of human ingenuity. We're talking inventions, literary and artistic works, unique designs, distinctive symbols.
Like logos.
Logos, brand names, yes. And even confidential business know-how, what we commonly call trade secrets.
Ah.
And for these creations, legal exclusive rights are recognized under law. Now, these aren't just abstract concepts. They translate into real power for creators.
Power how?
Well, the core purpose of IP rights is actually twofold. It serves a grander economic and societal function, really, beyond just individual protection.
You mentioned IP serves a grander economic and societal purpose beyond just individual protection. That's a fascinating perspective. Can you delve a bit deeper into what those broader functions are, especially for, a startup founder who's just trying to protect their idea?
Absolutely. So first, IP rights are designed to incentivize innovation. That's key.
Right. Encourage people to invent things.
Precisely. By granting creators a limited monopoly over their invention or creation for a set period, the law encourages individuals and organizations to invest significant time, money, and effort into developing new stuff. New products, artistic works, technological advancements.
Makes sense.
Think about it. Without the ability to exclusively commercialize their hard-earned innovations, there'd be little motivation for anyone to take on the risks and the costs associated with true pioneering work. I mean, who would pour millions into R&D if a competitor could just instantly copy their breakthrough for free?
Nobody, probably. It'd kill innovation.
Exactly. And second, and this is often overlooked, IP rights also facilitate the dissemination of knowledge.
How so? Doesn't protection mean keeping things secret?
Well, yes and no. In exchange for that limited monopoly, that temporary period of exclusive rights, especially with patents, the creator is generally required to publicly disclose the details of their invention or creation.
Ah, okay, so it's a trade-off.
It's a trade-off. This public disclosure then fosters a culture of continuous improvement, healthy competition, and overall technological and artistic progress. Others can learn from it, build upon it, or even design around what has been publicly revealed. It's a kind of societal bargain. You get protection for a time, but in return, you share the knowledge so humanity can advance.
That's a powerful point. So it's not just about locking down an idea forever. But here's where it gets really interesting for our listener, I think. When we talk about IP, it often sounds like something reserved for massive corporations, with huge legal departments.
Right.
But you're saying it's often the most valuable asset for a startup? How does that translate into real-world value for a brand new company, maybe one literally operating out of a garage?
It's a fundamental shift in how we understand company value.
Mm.
For startups, IP isn't just an asset, it's frequently the most valuable asset on their balance sheet, potentially.
More than their computers or desks.
Way more. Consider that many startups operate with minimal physical infrastructure, maybe a few laptops, some rented office space. Their true worth often lies entirely in their novel ideas, their unique algorithms, that distinctive branding or proprietary processes.
The secret sauce.
Exactly, the secret sauce. And because of this, investors, potential acquirers, strategic partners, they scrutinize a company's IP portfolio with intense focus during due diligence.
They really dig into it.
Oh, absolutely. They're looking to gauge several critical factors. Is this company's market position truly defensible? Can they fend off competitors, especially larger, well-funded ones?
Right. Can they survive?
Yeah. What are the potential revenue streams this IP could generate? Through direct sales, licensing agreements, maybe even enforcement down the line? And most importantly, does this IP indicate a strong likelihood of long-term market leadership? It's like the intangible backbone of their entire future.
So it's not just about protecting what you have now, but about proving your future value. It's like building a fortress, maybe. But for a lean startup, building a grand fortress sounds, well, daunting, resource-intensive. Where do they even begin when every single dollar counts?
It's an excellent analogy to think of it as building a moat. A strong IP portfolio acts as that defensible moat around your startup.
Okay, a moat. I like that.
It makes it significantly harder for competitors to encroach on your market share or directly copy your innovations. This moat provides a critical competitive advantage, especially against better-funded players who might otherwise just outspend or outmarket you.
Right.
For instance, think of a typical software startup. They might have a handful of servers, some laptops, maybe some office furniture, relatively few physical assets.
Yeah, standard.
But the vast majority of their value often resides in their proprietary code, the unique algorithms that power their service, the trademarks that define their brand and user recognition, and maybe some confidential know-how they've accumulated. Without robust IP protection for these intangibles, their entire business model could potentially be replicated by a competitor, undermining years of development and investment, often before they've even had a chance to gain significant traction.
Wow. Okay, so protecting that core value is paramount. Now that we know the fundamental power of IP, let's open up the inventor's toolkit.
Yeah.
Because it's not just one big hammer, right? It's a whole array of specialized tools, each designed for a different kind of innovation.
That's a crucial distinction, yeah.
What are the main categories of IP rights available that founders really need to understand?
That's a crucial distinction. Think of IP exactly like that, as a set of specialized tools, each tool suited for a different job. Understanding each type, its scope, its requirements, its strategic benefits, is essential for any startup trying to build a comprehensive protection strategy. Let's break down the big four. First up are patents. A patent grants the holder exclusive legal rights to an invention for a set period. Typically, that's 20 years from the date you file the application.
20 years, that's a long time.
It is. And this exclusive use means you can legally prevent others from making, using, selling, or importing your invention without your permission.
Okay. So what kind of things can you patent?
The subject matter is quite broad. It includes processes, machines, manufactured articles, and even compositions of matter like chemical compounds.
Right.
It's also worth noting that in some jurisdictions, software and even business method patents are also permissible, although that can be a complex and, frankly, evolving area of law.
Software patents sound tricky. So what does an invention need to be eligible for a patent? Is it just about being new? Can it be just any new idea I have?
Not just new, and definitely not just any idea. There are three core requirements you usually have to meet. First, novelty.
Okay, newness.
Right. The invention must be truly new, not previously disclosed to the public anywhere in the world. This means if you've already launched it or even talked about it publicly in detail, you might have already jeopardized your patentability.
Oh, okay. So keep it quiet initially.
Absolutely critical. Second, it needs an inventive step, which basically means it must be non-obvious to someone skilled in that particular field.
Non-obvious. What does that mean practically?
It can't just be a simple, predictable combination of existing elements. For example, you probably can't patent putting wheels on a suitcase today unless you've done something truly inventive with how the wheels are attached or how they function in a really novel way.
Right, because everyone does that now.
Exactly. And third, it must have industrial applicability, meaning it has some practical use or can be made or used in an industry.
So it has to be useful, basically.
Yeah, think of it simply. Your idea can't just be a theoretical concept. It needs to be something you can actually build, sell, or use in a practical way in the real world.
And the application process itself sounds pretty involved, almost like a complex legal negotiation. What does that entail for a founder? And what kind of costs are we talking about? Because that's always a concern.
It can be quite detailed, yes. The patent application is like writing the ultimate instruction manual for your invention. It's a detailed blueprint that someone else skilled in your field could theoretically follow to recreate it.
So you have to reveal how it works.
You do. That's part of the deal. This isn't just a formality. It's what ensures the breadth and strength of your protection. You draft a comprehensive specification describing your invention in meticulous detail, including drawings usually.
Okay.
Then you file it with a patent office, like the USPTO in the United States, the EPO in Europe, or the IPO in the UK. The application then undergoes an examination process.
Examination by who?
By a patent examiner. They essentially act as a detective, searching for prior art, any previously existing knowledge or technology that might be similar to yours.
To see if it's really new.
Exactly. There's often a back and forth, sometimes called office actions, where you argue or clarify why your invention is truly new and non-obvious. You might have to modify your claims.
Ah, okay. Negotiation.
A bit like that. The entire process, from drafting to actually getting the patent granted, can be lengthy, sometimes years. And yes, expensive. Costs can range from a few thousand to, well, tens of thousands of dollars over the prosecution process, not even including ongoing maintenance fees to keep it alive.
Tens of thousands. Wow. Given those costs and complexities, what are the truly strategic considerations for a startup when thinking about patents? Because for a lean operation, every dollar and every month counts.
Yeah, critical strategic considerations include deciding whether to file a provisional patent application first.
A provisional. What's that?
It acts as a placeholder. It secures an early filing date and gives you a year to refine your invention and prepare the full, non-provisional application.
Ah, buys you time.
It buys you crucial time and lets you say patent pending. This is often leveraged to gain early protection before, say, a critical funding round or a public product launch. Timing is absolutely everything here, as those public disclosures we mentioned can preclude patentability if not handled carefully.
Got it. File first. Talk later.
That's the safest route. It's also vital to understand the different types of patents available.
There's more than one kind.
Yep, there's the utility patent. This is the most common one. It covers new and useful processes, machines, articles of manufacture, or compositions of matter, or any new and useful improvement on those. This is your core invention protection.
Okay.
Then there are design patents. These protect the ornamental design of a functional item. They focus on how something looks, not how it works. Think of the unique aesthetic shape of a phone or a distinctive piece of furniture.
So the look and feel.
Exactly.
Huh.
And finally, there are plant patents. These are specifically for new varieties of asexually reproduced plants. More niche, obviously, but crucial for ag tech and biotech sectors.
Right. So beyond just keeping competitors away, what are the tangible, real-world benefits patents offer to a startup that make this potentially huge investment worthwhile?
The benefits are substantial and go beyond simple defense. First and foremost, a patent explicitly excludes competitors from copying key product features or processes. It gives you a strong legal basis to prevent infringement.
The legal stick.
Right. Secondly, and this is crucial for funding, a strong IP portfolio doesn't just attract investors, it actually changes the narrative of your valuation.
How so?
Many VCs see patents not just as a defensive shield, but as options on future markets, maybe even ones you haven't entered yet. It signals a far larger potential market and can justify a premium valuation.
Interesting. So it signals potential.
Exactly. And thirdly, patents can profoundly enhance your valuation during mergers and acquisitions, M&A, or licensing negotiations. They represent a tangible, transferable asset with measurable market exclusivity. It's solid proof of innovation and a clear competitive differentiator.
Okay, moving on from patents, what's next in the toolkit?
Next up, trademarks. These are rights in brand identifiers, basically anything that distinguishes your goods or services from those of others in the marketplace.
So logos, brand names.
Yes, names, logos, slogans. But it can also extend to sounds. Think of the Intel Inside Chime or even colors in limited circumstances, like Tiffany Blue. The core idea is really to prevent consumer confusion.
So if I just start using a unique name or logo for my new coffee shop, does it automatically become protected? Or do I have to go through some formal registration process, like with patents?
That's a really common question and a bit of a misconception. While many countries, like the US and UK, recognize unregistered common law rights simply by using a mark in commerce.
Meaning you get some protection just by using it.
You get some rights, yes, but typically limited to the geographic area where you're actually operating. Registration with a trademark office national like the USPTO or regional like the UAIPO in Europe confers significantly stronger, clearer rights.
Stronger how?
It gives you exclusive rights across a wider geographic area, usually nationwide or region-wide. It provides formal notice to everyone else of your claim, and it makes enforcement much, much easier if someone copies you.
Okay, so registration is definitely the way to go for serious protection.
Generally, yes. But registration isn't a one-and-done deal. Maintenance is required. You need periodic renewals, usually every 10 years. And crucially, you need active policing of infringement.
Policing, meaning?
You have to actively monitor the marketplace and defend your mark against unauthorized use. If you don't, you actually risk losing your rights over time through dilution or abandonment. You have to use it or lose it and defend it.
Wow, okay. Why are trademarks so important for startups then, beyond just having a cool logo? It seems like it's about more than just aesthetics.
Oh, their importance cannot be overstated, really. Trademarks safeguard your brand reputation and consumer goodwill. Your brand is often the first thing customers recognize and trust.
Connection point.
Exactly. A trademark protects that trust, that recognition, and the quality you promise. They can become incredibly powerful intangible assets, often commanding high valuation multiples during an acquisition because they represent established market presence and customer loyalty.
Right, people pay for the brand.
They do. Imagine trying to sell a product if a competitor could legally use the exact same name or logo. It would be a nightmare for customer recognition and trust.
Chaos.
Total chaos. Are there different kinds of trademarks too, like with patents?
Yes, just like patents, there are different forms, word marks. These protect the actual name, letters, or numbers of your brand, regardless of font or style. Think Google or Apple written in any standard typeface.
Just the word itself?
Just the word. Figurative marks. These are logos and images. Think the Nike swoosh or the Apple bitten Apple logo.
The visual symbol.
Right. Composite marks. As the name suggests, these combine words and logos, protecting them as a single unit.
Okay.
And as I mentioned, in limited jurisdictions, you can even trademark sound, smell, and color marks, though these are far less common and have pretty strict requirements, usually reserved for very distinctive, well-known brands.
Smell marks. Seriously?
Yes, though very rare. Think about the distinct scent of Play-Doh, for example. Huh. Okay, so for startups just getting off the ground, what are some key branding tips around trademarks? I can just imagine a founder getting super excited about a name and then finding out it's already taken. That must happen all the time.
It happens all the time, and it can be heartbreaking and expensive. So for startups, the best practices are clear and mostly preventative. First, conduct thorough trademark clearance searches before you launch your brand or product.
Before you print business cards or build the website.
Absolutely. Discovering a conflict after you've invested heavily in marketing, packaging, and building a customer base can be devastating. It could force an expensive, complete rebrand right when you can least afford it.
Nightmare scenario.
Total nightmare. Secondly, secure domain names and social media handles early that align with your chosen brand. This prevents cyber squatting, where someone else grabs your name online to sell it back to you, and ensures brand consistency online, which is vital today.
Good point. Grab those handles.
Grab them quick. Finally, file trademark applications in your key markets, especially if your business involves e-commerce and you expect a global customer base. Don't wait until you're already successful in a new region to protect your brand there. You might find a local competitor has already claimed your name, blocking you out.
Proactive, proactive, proactive.
Okay, next category, copyright. This type of IP protects original literary, artistic, musical, and very importantly for tech startups, software works.
Okay, so books, music, art, code.
Exactly. It's about protecting the expression of an idea, not the underlying idea itself. That's a key distinction.
Expression versus idea. Got it. So if I read a fantastic piece of software, is my code automatically protected or do I need to register it for it to count, like with trademarks?
That's a great question, and it highlights a key difference from patents or trademarks. In most jurisdictions around the world, copyright protection is automatic upon creation.
Automatic. Really?
Yes. As soon as you put your original thoughts down in a tangible form, whether that's writing code, composing a song, sketching a design, writing a blog post, you automatically gain copyright in that expression.
So no forms to fill out initially.
Not necessarily for the right to exist. However, while formal registration isn't strictly necessary for protection, it does provide significant evidentiary advantages if you ever get into a dispute.
Advantages like what?
Well, in many places, like the U.S., you generally need to have registered your copyright before you can sue someone for infringement. Registration also creates a public record of your claim and can entitle you to claim statutory damages and attorney's fees in a lawsuit, which can be very valuable.
Oh, okay. So registration makes enforcement much stronger.
Much stronger, yes.
Yeah.
Now, the scope of copyright covers the expression of a work, for example, the specific lines of code you wrote, the layout of a user interface, the exact text of your pitch deck, or the imagery in a marketing video.
But not the idea behind the code.
Crucially, no. Copyright does not cover the underlying ideas, procedures, methods of operation, or functional aspects of a work. So someone else could write different code to achieve the same function without infringing your copyright, although they might run into patent issues if the function itself is patented.
Okay. That's a tricky line. How long does copyright last?
It lasts a long time.
Mm-hmm.
Often it's the life of the author plus 50 or 70 years, depending on the country. Or for works made for hire, like work done by an employee for a company, it's often a fixed term, maybe 95 years from publication or 120 years from creation.
Wow, much longer than patents. So what are the biggest, most critical takeaways for startups regarding copyright? Where do founders typically trip up? I feel like the ownership thing could be a big one.
It is huge. For startups, it's vital to, one, identify your protectable assets. Be aware of what you're creating that has copyright. This includes your source code, obviously, but also user interfaces, documentation, marketing materials, videos, blog posts, even your pitch decks. These are all original expressions that copyright protects.
So basically anything creative you produce.
Pretty much. 2, ensure contracts with freelancers and agencies assign copyright to the company. This is absolutely critical, and it's where so many startups stumble, especially early on.
Why is that such a big deal?
Because if an external developer or design agency creates something for your startup without a clear written assignment clause stating the company owns the IP, the default legal position in many places is that the creator, the freelancer or agency, might own the copyright, not your company, even if you pay them.
Even if you pay them?
Even if you paid them. I remember working with a founder once, brilliant tech guy, so focused on building their product. They used a freelance developer for a core module, just based on emails and invoices. Fast forward to their Series A funding round.
Oh, no.
Yes. The investors' due diligence team asked, can we see the IP assignment agreement for this core piece of code? And the founder's face just dropped. They didn't have one. It almost derailed their entire funding round because the investor rightly asked, do you even own the core technology of your own company?
What a nightmare. So get it in writing. Always.
Always, always get it in writing. Work for hire clauses or explicit assignment clauses are essential. 3, emphasize avoiding infringement. This sounds obvious, but it's easy to slip up. Only use properly licensed third-party content. Don't just grab images, music, or code snippets you find online and assume they're free to use. Always secure the necessary rights or use clearly licensed open-source material according to its terms. Ignorance is rarely a valid defense in copyright law, and lawsuits can be incredibly costly and damaging to your reputation.
Okay, that ownership point is huge. What's the last main tool in the IP toolkit?
Finally, we come to trade secrets. This category protects confidential business information that provides a commercial advantage, specifically because it is not generally known to the public or competitors.
So things you deliberately keep secret?
Exactly. This can include formulas like the Coca-Cola recipe,
The classic example.
the classic, but also manufacturing processes, detailed customer lists, unique algorithms, even marketing strategies or pricing information potentially. Anything that gives you an edge because others don't know it.
So how do you protect a trade secret if it's not registered anywhere, like a patent or a trademark? Is it literally just about keeping it under wraps?
Precisely. The protection for trade secrets comes entirely from keeping the information secret. There's no government office you register it with. Protection relies on implementing robust protection mechanisms internally.
Like what kind of mechanisms?
Well, having employees and partners sign legally binding non-disclosure agreements, NDAs, is fundamental. Establishing strict internal security protocols around sensitive data is crucial. The limited access to servers, strong encryption, need-to-know access controls. Implementing clear employee X procedures to ensure confidential information doesn't walk out the door with departing staff is also key. And sometimes even physical security measures for tangible secrets, like keeping a formula locked in a vault.
So it's all about active effort to maintain secrecy. What are the advantages and, I guess, the risks of relying on trade secrets? It sounds like maybe a double-edged sword, potentially powerful if maintained, but maybe fragile if exposed.
It absolutely is a double-edged sword. The advantages are compelling for startups. First, there's no expiration date. Unlike patents, which have that limited 20-year term, a trade secret can theoretically last forever, as long as it stays secret.
Like Coke's recipe.
Exactly. Second, there are no registration costs or formal processes, which is attractive for cash-strapped startups. And third, you get immediate protection as soon as the information is established as a secret, and you take reasonable measures to keep it that way.
Sounds good. What's the downside?
The risks are equally significant. There is no legal remedy if the secret is independently discovered by a competitor through their own research, or if it's successfully reverse-engineered from your product, or, critically, if it's leaked through a breach of confidentiality that you couldn't reasonably prevent despite your best efforts.
So if someone figures it out fair and square, or steals it despite your precautions,
Then the protection vanishes. The greatest strength of a trade secret, its secrecy, is also its biggest vulnerability. The moment the information becomes public knowledge, you lose that competitive edge, and the trade secret protection disappears.
can you give us some other famous examples of trade secrets besides Coke that really illustrate their power and the high stakes involved?
Certainly. Google's core search algorithm is often cited as a prime example. It's given them a massive competitive edge for decades, and they guard it fiercely as a trade secret, rather than patenting it, which would require disclosure.
Right, they don't publish how it works.
Exactly. Another might be the recipe for WD-40, supposedly known only by a few people. And many specialized manufacturing processes used in biotech or advanced materials, firms are kept as trade secrets because the process itself is the key advantage, and patenting might reveal too much or be hard to enforce. These are invaluable assets precisely because they remain proprietary through diligent internal security and confidentiality agreements.
So for startups, what are the absolute best practices for handling trade secrets? It sounds like identifying what is a secret and controlling access are paramount.
Absolutely. For startups, the best practices are: 1. Identify your key trade secrets. You need to pinpoint exactly what information gives you a competitive advantage that you need to keep confidential. Don't try to label everything as a secret. That dilutes the importance. Focus on the truly impactful data or processes.
Be selective.
Be selective and strategic. 2. Classify and control access meticulously. Not everyone in the company needs access to every piece of sensitive information. Implement a strict need-to-know basis. Limit who sees what based on their role, and use technical controls like password protection and access logs.
Least privilege principle.
Exactly. 3. Educate employees about confidentiality. This is huge. Make sure every single team member understands what constitutes a trade secret and their legal and ethical obligations to protect it. This needs to be part of onboarding, reinforced regularly, and addressed clearly during exit interviews. This includes training on cybersecurity best practices and clear policies on what information can and cannot be shared externally, even informally.
Okay, so we've got the toolkit, patents, trademarks, copyrights, trade secrets. Here's where it gets really powerful, I think. We've defined them, but how do startups actually use this knowledge strategically? It's one thing to know what a patent is, quite another to build a dynamic strategic approach around it. How do you go from just definitions to an active, proactive IP strategy that truly fuels growth?
That's exactly the right question. It's the leap from understanding the tools to actually building something effective with them. A proactive IP strategy is vital, and it needs to start from the earliest stages of a startup's life. And it's not static. It has to evolve as the company grows, especially as you think about international expansion and eventually monetization. It's definitely an ongoing process, not a one-time task.
So early stage, you've just got an idea, maybe a prototype. What's step one?
At the very early stage, The first step is often what's called a gap analysis or an IP audit.
An audit. Sounds formal.
It can be, but it doesn't have to be overly complex initially. It basically involves systematically identifying all existing and potential IP assets within your company. Things that could be patents, trademarks you're using or planning, copyrightable materials you've created, and potential trade secrets. You need to know what you have, what you could have, and where your vulnerabilities might lie. It's like taking inventory of your most valuable, often invisible, assets.
Okay, map out what you've got. And once you know what you have, or could have, how do you decide what to protect first, especially with those limited resources that every early-stage startup faces? It must be a constant push and pull between the cost and the potential benefit, right?
Absolutely. That leads directly to prioritization. Startups almost always operate with limited budgets, so you have to focus your resources, both time and money, on the IP types that most directly align with your core business model and provide the most significant competitive advantage.
So tailor it to your business.
Exactly. For example, a hardware startup innovating with a novel physical device might heavily prioritize utility patents to protect its core functionality. That's probably their main differentiator.
Makes sense.
A software startup whose unique value is maybe in its proprietary algorithms might lean more towards trade secret protection, maybe supplemented by copyright for the specific code implementation, and perhaps patents if the algorithm meets the criteria. A consumer brand, on the other hand, will likely prioritize trademarks from day one to build and protect its brand recognition and goodwill. That's their key asset.
So you have to weigh the costs versus the benefits.
Constantly. The significant upfront and ongoing costs of filing and maintaining IP, especially patents, must be justified by the competitive edge it provides. You simply can't patent everything, everywhere. You have to choose your battles wisely, focusing on what truly protects your core value proposition.
So it's not just about, say, getting a patent, but having a documented living plan for how you'll manage all your different types of IP, almost like a business blueprint specifically for your intellectual assets.
Precisely. It's really crucial to establish an IP strategy document early on. This isn't just about legal filings. It's an internal, living document that outlines your company's processes for managing IP.
What goes in that document?
It should cover key processes like invention harvesting. How do you actually identify new innovations coming from your team that could be patentable or valuable trade secrets? Who reviews these ideas internally? What's the decision-making process for deciding whether and how to protect them?
So you don't miss things.
Right. Trademark clearance and brand protection.
Yeah.
What's your systematic approach for researching new potential brand names and logos before you commit? And then, what's the plan for protecting them in relevant markets? Copyright management. How do you ensure your company clearly owns the copyright to all developed works, whether created internally by employees or externally by freelancers or agencies? What clauses are standard in your contracts?
That ownership point again?
Always critical. Confidentiality policies and protocols. What are the internal rules, technical measures, and training programs you put in place to protect your trade secrets? How do you handle NDAs and employee exits? Having this documented provides clarity, consistency, and helps build an IP-aware culture.
Okay, so you've got your initial strategy. What happens when the startup starts looking beyond its home market? International growth seems like the goal for many.
Right, and when that happens, a critical reality sets in. IP rights are territorial in nature.
Meaning country by country.
Essentially, yes. A U.S. patent, for example, only protects your invention within the United States. A U.K. trademark protects you in the U.K. Filing for IP protection in every single country you might eventually want to operate in can quickly become prohibitively expensive, almost impossibly so for most startups.
That sounds like a huge barrier for global growth, especially in today's digital economy where your customers could potentially be anywhere. Are there any streamlined ways to manage international filings, or is it always just a painful country-by-country headache?
Fortunately, yes, there are international systems designed to make this process more efficient and cost-effective, at least initially. Though, importantly, they don't grant a single global IP right with one application.
Okay, so what are these systems?
For patents, there's the Patent Cooperation Treaty, PCT. This allows you to file a single international application that essentially reserves your right to pursue patent protection in over 150 member countries for a certain period, typically 30 or 31 months from your initial filing date.
So it buys you time globally.
Exactly. It acts as a placeholder and gives you a significant discovery period. You get nearly 2.5 years to assess market potential in different countries, refine your strategy, maybe secure funding. before you have to commit to the significant costs of entering the national phase, filing individual applications in specific countries you choose.
That sounds incredibly useful. Is there something similar for trademarks?
Yes, for trademarks, there's the Madrid Protocol. It offers a similar streamlined system. You can file one international application with your home trademark office and designate multiple member countries where you want protection. It simplifies the management and renewal process significantly compared to filing separate national applications everywhere.
Okay, PCT for patents, Madrid for trademarks. So how does a startup decide which countries to prioritize using these systems? You still have to choose eventually, right? Balancing those costs with ambitious global aspirations, it feels like a strategic tightrope walk.
It absolutely is a strategic decision, and it has to be based on your specific business plan and market reality. You need to determine your core markets for protection.
How do you figure that out?
You look at factors like where your biggest potential customer base is, where do you plan to manufacture your products, if applicable, where are your key strategic partners or major competitors located, and sometimes where do your investors expect you to have protection?
Right, investor expectations matter.
They often do. So for geographic strategy, some key tips usually include always file first in your home market. That's usually where you're based and likely to begin operations first. Then prioritize markets with significant customer bases, where you intend to conduct manufacturing, or where you have crucial partnerships. This directs your limited resources where they offer the most immediate and tangible benefits or mitigate the biggest risks. Finally, it's a constant balance of costs with the risks of infringement. You likely can't afford to protect everywhere, so you must strategically choose the jurisdictions where the risk of being copied or blocked by competitors is highest and where the potential reward of having exclusivity is greatest. It's all about smart resource allocation.
Okay, so protection is key. But IP isn't just about defense, right? You mentioned leveraging it. How can startups actually use their IP offensively, maybe to generate revenue?
Absolutely. IP is a powerful tool for offense and generating revenue, not just a shield. Licensing is probably the primary way to monetize your IP without selling it outright.
Licensing. So letting someone else use your tech or brand.
Exactly. It involves granting permission to another party to use your IP, your patent, trademark, copyright, maybe even know-how under specific, agreed-upon terms, typically in exchange for payment.
What are the different ways you can structure those licensing agreements? It sounds like it could be quite flexible depending on the business need.
You're right. It's very flexible. You can have exclusive licenses, which grant the licensee sole rights to use the IP in a certain field or territory. Sometimes this excludes even the IP owner themselves from using it in that specific scope.
Wow. Okay.
Or, more commonly perhaps, you can have non-exclusive licenses, which allow the IP owner to license the same IP to multiple parties simultaneously. Licenses can also include field of use restrictions, meaning the licensee can only use the IP for specific applications or industries. For example, you might develop a platform technology. You could license it exclusively to Company A for use in healthcare, but not exclusively to Company B for use in the financial sector, allowing you to carve up the market and maximize revenue from different verticals.
That sounds smart. What other strategic ways can you use licensing?
Another strategic approach is cross-licensing and partnerships. This involves two or more companies licensing their IP to each other.
Why would they do that?
It's often used strategically to mitigate infringement risk. If you think you might be infringing on someone else's patent, and they might be infringing on yours, you can agree to cross-license, essentially calling a truce and allowing both to operate freely. It can also expand market access by allowing partners to bundle technologies or leverage each other's innovations, creating symbiotic relationships.
Okay, makes sense. And what about the actual money aspect? How do startups typically earn revenue from licensing? Is it just like a one-time fee, or are there recurring revenue streams involved?
It can definitely be a mix structured to fit the deal. The most common revenue streams include royalties. These are ongoing payments, usually calculated as a percentage of sales or based on usage of the licensed IP. This gives you recurring revenue tied to the licensee's success. Upfront license fees. This is often a lump sum payment made at the beginning of the agreement, giving you immediate cash flow. Milestone payments. These are payments triggered when the licensee achieves certain pre-agreed developmental or commercial targets. For instance, a biotech startup might license a new drug compound,
Right.
receiving an upfront fee, then additional milestone payments as the drug successfully progresses through phase 1, phase 2, phase 3 clinical trials, and then finally ongoing royalties once it actually hits the market and starts generating sales.
So you can structure it to match the development risk and reward.
Precisely. And beyond traditional licensing, there are several other potentially powerful monetization routes for IP. IP-backed loans. Some specialized lenders are increasingly willing to provide financing using your intellectual property portfolio as collateral, recognizing its inherent quantifiable value.
Using your patents as collateral.
Yeah. Yes, it's becoming more common, especially for IP-rich companies. Patent pools. These are agreements where multiple patent holders bundle their patents related to a specific technology standard, think Wi-Fi or certain video codecs, and license them together, often to facilitate wider adoption of the standard and share royalty income. Out-licensing in adjacent verticals. If your core product focuses on one industry, say automotive, you might license your underlying technology to companies in other non-competing industries, like aerospace or medical devices, generating revenue without impacting your core market. Assignments to spinouts. You might identify a specific piece of IP that could form the basis of a whole new business. You could transfer those specific IP assets to a new, separate company, a spinout formed specifically to develop that application or product. Effectively, you're turning IP into seed capital for a new venture, perhaps retaining equity in the spinout.
Okay, so we've talked about protecting your ideas and leveraging them strategically. But let's be real, the path isn't always smooth. It sounds like there are dangers too. So what does this all mean for you, the listener, if you're trying to launch something? Particularly when it comes to avoiding common and often really costly mistakes that can completely derail your entire venture.
This is absolutely where proactive diligence really pays off. So many startups stumble into easily avoidable pitfalls that can seriously jeopardize their IP, often just due to excitement, maybe a lack of awareness, or simply trying to move too fast without thinking through the IP implications. Understanding these common mistakes is honestly just as important as understanding the types of IP themselves.
Okay, hit us with the big ones. What's pitfall number one?
The first major pitfall, and one that trips up countless inventors, is the public disclosure pitfall.
Disclosing too early.
Exactly. The issue here is critical. Disclosing your invention, whether that's by publishing it in an article, presenting it at a conference, selling a product that incorporates it, or even just publicly pitching the details, before you file a relevant patent application, can completely preclude patentability in many, many countries.
Can completely kill your patent rights.
It totally kill them. Most countries outside the U.S. operate under an absolute novelty system. This means any public disclosure anywhere in the world before your patent filing date can destroy your ability to get a patent there. Some countries, like the U.S., do offer a limited grace period, usually 1 year from your own disclosure. But relying solely on that can be risky and limits your international options significantly.
You know, it's almost counterintuitive for founders, isn't it? You're so excited about your breakthrough, you naturally want to shout it from the rooftops. But legally, that's often the absolute last thing you should do before getting your patent filings in order. So if you've got this fantastic new gadget or a really novel software feature, you really can't just talk about it freely before you filed.
Pretty much, yes, if you want robust patent protection, especially internationally. The clear best practice is to file at least a provisional patent application, or use robust confidentiality agreements, NDAs, before any public disclosure.
That provisional again?
That provisional is your friend here.
Yeah.
It secures your filing date for a year, gives you time to refine the invention and prepare the full non-provisional application, while still allowing you to discuss it under the umbrella of a patent pending status. It buys you crucial time and protection.
Okay. What are some common ways founders accidentally disclose?
Common examples of public disclosure that can inadvertently undermine your patent rights include startup pitch competitions, presenting your innovative solution in detail to a panel of judges or a public audience without having filed first. Imagine a founder beaming with pride, showcasing their revolutionary AI tool at a tech demo day, only to realize later they've legally shot themselves in the foot for patent protection in Europe or Asia. Big ouch. Conference presentations, sharing technical details in academic papers or industry forums, product launch campaigns, announcing and describing new, inventive features to the market before filing. Each of these activities can potentially act as prior art against your own future patent application, effectively making your own invention non-novel in the eyes of the law.
Wow. Okay, that's a huge one. What's the next major pitfall?
Another massive pitfall, and one that causes immense headaches, especially during funding rounds or acquisitions, is overlooking ownership issues.
Ownership, meaning who actually owns the IP.
Precisely. This typically arises from ambiguous, or worse, non-existent employee or contractor agreements. This ambiguity can lead to unclear IP ownership and, almost inevitably, costly disputes down the line. If it's not explicitly clear in writing who owns the IP that was created, a departing employee or a contractor could potentially claim rights to your core technology, essentially holding your business hostage later on.
So just to be clear, if someone develops something for your company, you can't just assume the company automatically owns it, even if you paid them for the work. That seems really counterintuitive to a founder who's just trying to build a product.
Exactly. It feels wrong, but the default legal position in many jurisdictions is that the creator, the individual employee or the contracting entity, owns the IP they create, unless there's a clear written agreement stating otherwise, transferring those rights to the company.
So the paperwork is everything.
The paperwork is absolutely everything here. The best practice is to use well-drafted invention assignment clauses in all employment contracts and specific work-for-hire or assignment agreements with all consultants and freelancers. These clauses explicitly state that any intellectual property created by the employee or contractor during their work for the company and related to the company's current or anticipated business is automatically signed to and owned by the company. This ensures the company owns all the developed IP, leaving no room for doubt later.
Where exactly should these clauses be included?
They need to be baked into your standard documents. Employment contracts. For all your full-time and part-time employees right from the start. Consultant freelancer agreements. For any external individuals or agencies you hire to develop software designs, content, algorithms, anything that could potentially generate IP. Don't rely on handshake deals or simple invoices. Get a proper agreement with IP assignment language. Founders agreements. This is often overlooked. Even among the founding team, it's absolutely crucial to clarify in writing who owns the IP developed by each founder prior to the company's formation, background IP, versus during the company's life, foreground IP, and how IP created within the company will be owned moving forward. This prevents potentially devastating internal strife later on.
Okay, nail down ownership in writing. Got it. What's pitfall number 3?
The third common pitfall is inadequate record keeping.
Just not keeping good notes.
Essentially, yes. Failure to meticulously document your development process, your invention timelines, who invented what when, design iterations, experiments. This can severely undermine your ability to enforce your IP rights later, or even defend yourself against claims of infringement from others. If you can't prove when and how your invention came to be, or who was involved, your claims to ownership or novelty can be much more easily challenged in a dispute. It's like trying to prove you built a house without any blueprints, receipts, or construction logs.
What kind of records should startups be keeping them? Beyond just like the final version of the code or the final design, what specific documentation is really vital to protect against these future challenges?
The best practice is to maintain inventor notebooks, digital or physical, use robust version control systems diligently, and keep detailed documentation of your innovation timelines. These records provide crucial contemporaneous evidence. For instance, timestamped Git commits for software development are invaluable. They show exactly who wrote what code and when.
Good developer practice anyway.
It is, but it has IP value too. Internal invention disclosure forms are very powerful. These are simple forms where inventors record new ideas, describe them, list the creators, date it, and ideally get it witnessed. It creates a formal record. And even just detailed meeting notes that capture discussions around new ideas, technical developments, design decisions, and key breakthroughs can serve as powerful evidence of when an idea was conceived, who contributed, and how it was reduced to practice. These seemingly mundane records can be absolutely invaluable in proving inventorship, originality, and the timeline of your innovation, should you ever need to defend it in court or negotiate a license.
Okay, document everything. Makes sense. What's the last big pitfall?
Finally, we often see startups fall into the trap of reactive versus proactive enforcement.
Meaning they wait until there's a big problem.
Exactly. The issue is that waiting until a clear, significant infringement occurs before taking any action can be far more costly and damaging than being proactive. By the time a competitor has deeply copied your product and saturated the market, the damage to your market position or brand reputation may already be substantial. And the legal costs for litigation to stop them can be astronomical, potentially bankrupting a startup. It's like waiting for your house to be fully engulfed in flames before calling the fire department, instead of having smoke detectors and maybe a fire extinguisher handy.
So it's about spotting potential issues before they become full-blown catastrophic problems. What does that proactive monitoring actually look like for a startup that probably doesn't have a huge dedicated legal team watching everything?
Precisely. It's about early detection and deterrence. The best practice is to actively monitor competitor filings, patents and trademarks, key marketplaces where your products are sold, and relevant online platforms for potential infringements.
How do you do that practically?
You can set up alert systems, maybe using Google Alerts for brand names, or more specialized IP watch services that monitor new patent or trademark applications in your specific technology field or geographic markets. You also need to actively search online marketplaces and app stores for unauthorized use of your brand name, logos, or copyrighted content. And you need to be prepared to send cease and desist letters promptly when you identify potential infringement.
Does sending a letter always mean starting a huge fight?
Not necessarily. Often, a well-drafted, professional cease and desist letter sent early can resolve the issue quickly and relatively cheaply. Speed is often key in deterring widespread copying and preventing smaller, maybe unintentional infringements from snowballing into major threats. It shows you're serious about protecting your rights.
Are there resources to help with this beyond just hiring expensive lawyers for everything?
Yes, definitely. Consider leveraging these resources, IP Watch services. As mentioned, these specialized services can automate the monitoring of new filings or market activity relevant to your IP, sending you alerts so you don't have to search manually all the time. Legal counsel with pre-prepared cease and desist templates. Having your lawyer draft standard templates for common infringement scenarios allows you to respond quickly and professionally when needed, without incurring huge legal fees for every single letter you send. Marketplace takedown mechanisms. Platforms like Amazon Brand Registry, Etsy's IP reporting tool, or similar programs on Shopify and app stores offer specific tools for registered brand owners to easily report and request the removal of infringing listings. These can be a surprisingly fast and effective way to protect your e-commerce presence without having to resort to court immediately.
Okay, this leads directly to another really important question. We've talked a lot about protecting ideas, avoiding pitfalls, but how does all this IP stuff directly influence the money side of startups? Specifically, getting funding and determining valuation. Because let's face it, for many founders, attracting investment is absolutely key to scaling their vision, and investors are notoriously particular about where they put their money.
This is a critical intersection, definitely, and one founders sometimes underestimate the importance of until they're deep in fundraising discussions. For investors, particularly venture capitalists, VCs, and corporate investors, a startup's IP portfolio is often seen as a direct indicator of its future viability, its defensibility in the market, and its potential for generating significant returns. It's really not just a nice-to-have, it's often a fundamental make-or-break factor in their investment decision.
So investors really care about patents and trademarks. It's not just about the team in the market.
They care deeply. During the due diligence process, which happens before they invest, VCs and corporate investors conduct extensive evaluations of a startup's IP. They're not just counting the number of patents you have, they're scrutinizing the quality and relevance of the IT portfolio. They'll often demand freedom to operate, FTO analyses.
Freedom to operate, what's that?
An FTO analysis assesses whether your product or service potentially infringes on existing third-party IP rights. Investors want to know if you're likely to get sued for infringement right after they give you money.
Ah, okay. Makes sense they'd want to avoid that.
Absolutely. They'll also review all your pending IP applications, examine any history of IP litigation you might have been involved in, and critically assess the ownership documentation we talked about earlier. They want to ensure your core innovation is truly protected and that you won't face costly legal challenges down the road that could drain their investment capital or even shut down the business. Imagine you're buying a house. An FTO search is kind of like hiring a surveyor to make absolutely sure your new house isn't accidentally sitting on someone else's property or that your building plans don't violate any existing zoning laws. You want to know you're clear before you commit.
So a strong IP portfolio can literally change your company's valuation. It's not just some soft background factor. It directly impacts the numbers on the term sheet they offer you.
Absolutely. It can have a direct and significant impact.
Yeah.
Strong, well-protected, strategically relevant IP can justify significantly higher valuations because it demonstrates a defensible market position, a unique selling proposition that competitors can't easily copy, and potentially a formidable barrier to entry for others. It signals to investors that their investment is better protected and has a clearer, less obstructed path to market dominance and eventual returns. Conversely, identifiable gaps in your IP protection or significant IP risks like a high probability of infringing someone else's patent can trigger substantial discounts on your valuation or even become outright deal breakers, causing investors to walk away entirely. Investors fundamentally see robust IP as a crucial safeguard for their investment, ensuring your competitive advantage isn't easily eroded away.
So founders need to be really prepared to talk about their IP during fundraising.
Thoroughly prepared. When engaging with potential investors, they should present their IP clearly in the data room. Make all relevant documents, filed patents, applications, trademark registrations, key IP agreements easily accessible and well organized for the investor's review team. Don't make them hunt for critical information. Prepare clear summaries of claim coverage, especially for patents. Don't just dump technical documents on them. Explain what your patent claims actually protect in simple business terms. Highlight their strategic value and market implications, not just the dense legal jargon.
Translate it for them.
Exactly. Translate the legalese into business value. Highlight competitive differentiators linked directly to IP. Explicitly connect your unique IP assets, your patents, your trade secrets, your strong brand to why your company is better, faster, cheaper, or more defensible than competitors. Show them precisely how your IP creates a durable, sustainable market advantage they can invest in.
Okay, so IP influences valuation. Does it also affect the actual terms of the investment deal itself, like the fine print in the term sheet?
Yes, IP considerations often extend right into the very structure of term sheets, which outline the basic terms and conditions of an investment before the final legal documents are drafted. It's not uncommon at all for investors to include specific milestones and covenants related to IP protection.
Meaning conditions they impose.
Exactly. For instance, they might require the company to file a certain number of patent applications by a specific future date as a condition of receiving the next tranche of funding. Or they might require you to ensure the ongoing maintenance of key trademarks, or even implement new, more robust IP protection policies and procedures within the company as a condition of their investment. They're actively protecting their stake by ensuring the underlying assets are secure.
And what about this term IP carve-outs? That sounds like it could be a potentially tricky area, especially for founders who might have been tinkering on related projects or ideas before the company even formally existed. How does that work?
It can definitely be tricky and requires careful negotiation. IP carve-outs refer to the negotiations, usually during the investment process or company formation, over background IP versus foreground IP.
Background versus foreground.
Right. Background IP is intellectual property developed by the founders before the company was officially formed. They might want to retain full or partial ownership of this pre-existing IP, perhaps licensing it to the new company. Foreground IP, on the other hand, is IP developed by the company after its formation using company resources, which is typically expected to be fully owned by the company itself.
So you have to be really clear about what was created when and who owns what.
Absolutely. These discussions can be quite nuanced and require careful legal drafting in the founders' agreements and investment documents to ensure complete clarity and avoid potentially explosive disputes later on over who owns what critical piece of the technology puzzle. It's vital to get this ironed out explicitly, early, and in writing.
What other IP-related things might show up in a term sheet?
Other critical considerations that might appear include rights of first refusal on IP sale. This would give the investors the right to purchase your key IP assets if the company ever decides to sell them to a third party. It gives them a measure of control over where those crucial assets end up. Lockup periods on founder-held IP. If founders retain ownership of some background IP that's crucial to the company, investors might restrict them from selling or transferring that personal IP for a certain period after the investment, ensuring stability and continued access for the company. Equity adjustments based on IP transfers. In some situations, the formal transfer of valuable pre-existing founder IP into the company might be tied to specific equity allocations or adjustments for that founder, reflecting the perceived value that IP brings to the new venture right from day one.
Okay, so you've diligently built your IP portfolio, you've maybe secured funding, and you're moving forward building the business. But what happens when things inevitably go wrong? When a dispute arises? Maybe someone infringes on your IP, or even worse, you get accused of infringing someone else's. That sounds potentially terrifying and incredibly daunting for a startup, especially one with limited resources to fight prolonged legal battles.
It definitely can be daunting, yes, but understanding your options for resolving IP disputes, and importantly, having defensive strategies already in place before a conflict arises, can mitigate much of that daunting feeling. The goal really should be to resolve conflict as efficiently and cost-effectively as possible so you can get back to focusing on your business.
So what are the main options when a dispute pops up? Is it always just straight to court?
Not necessarily, though that's often what people think of first. When IP rights are infringed or you find yourself accused of infringement, there are actually various options for resolution. The most well-known, as you say, is court litigation, which involves formal legal proceedings through the judicial system.
The big, expensive lawsuit.
Often, yes. However, there are also effective alternative dispute resolution, ADR methods. These include arbitration, where a neutral third party hears the case and makes a binding decision, much like a private judge, and mediation, where a neutral third party helps the conflicting parties negotiate and reach their own settlement but doesn't impose a decision. Additionally, specifically for patents, you might engage in patent office oppositions or re-examination processes, which occur administratively before the patent office itself rather than in a formal court.
Litigation always sounds incredibly expensive and just massively time-consuming. Is that universally true, especially for startups? And are there hidden costs beyond just the obvious legal fees?
Unfortunately, yes, cost considerations are paramount, and litigation is notoriously expensive. IP litigation, particularly patent litigation, can easily run into the hundreds of thousands or even millions of dollars. And it's incredibly time-consuming, potentially diverting critical management attention and engineering resources away from your core business for months or even years.
Distraction factor.
Yeah, huge distraction factor. Furthermore, there's always the significant risk of counterclaims. The party you accuse of infringement might turn around and accuse you of infringing on their IP, suddenly escalating the conflict and doubling your legal exposure. And don't underestimate the reputational impact. Litigation is often public, and win or lose, it can cast a shadow on a company, potentially impacting customer trust, employee morale, or future investment prospects.
Okay, so litigation sounds like a last resort, if possible. What are the more startup-friendly options, then?
For startups, the focus should generally be on startup-friendly options that prioritize efficiency, cost control, and speed to resolution. Settle early, perhaps with non-monetary remedies. Often a well-drafted cease and desist letter followed by prompt negotiation can resolve a dispute relatively quickly. You might agree on terms where the other party stops the infringing activity, maybe takes a license or agrees to modify their product, the design around, all without huge financial outlays or protracted battle. The primary goal is often just to stop the harm, not necessarily to extract a massive damages award.
Get them to stop copying.
Exactly. Stop the bleeding. Use patent office re-examination or review mechanisms. In the U.S. and other places, there are administrative processes within the patent office itself, like inter partes review or post-grant review, that can be a more cost-effective way to challenge the validity of an opponent's patent or defend your own without going through the full expense and complexity of federal court litigation. The standards can sometimes be different, too. Explore arbitration clauses in contracts. By including well-drafted arbitration clauses in your commercial agreements with partners, suppliers, maybe even customers, you pre-agree with the other party to resolve any future disputes through arbitration instead of court. Arbitration is generally faster, less expensive, more private, and potentially less adversarial than traditional court litigation.
Okay, those are good options for resolving disputes. What about the flip side? Defending yourself if someone accuses your startup of infringement. How do you prepare for that possibility?
That's equally important. Having a robust defensive strategy in place before you get that cease and desist letter is crucial. Key strategies include conducting those freedom to operate FTO searches we mentioned earlier, ideally before you launch a new product or feature. This proactively identifies any existing third-party IP that your product might potentially infringe, allowing you to modify your design, seek necessary licenses, or prepare your defense before you're caught off guard by an accusation. It's preventative medicine for IP.
Know the minefield before you walk into it?
It's exactly. Securing indemnity from licensors. If you license technology from another company to incorporate into your product, try to ensure your licensing agreement includes a strong indemnity clause. This means the company you license from agrees to defend you and cover your costs if you get sued for infringement related to their licensed IP. This effectively passes the risk back to the original IP owner. Maintaining defensive patent publications. It's an interesting strategy. Sometimes if you have an invention that might be patentable, but you don't necessarily want to go through the cost and disclosure of patenting it yourself, you might choose to publish the details in a recognized technical journal or a dedicated defensive publication database. This deliberately puts the invention into the public domain as prior art.
Why would you do that?
To prevent anyone else, including your competitors, from being able to patent that specific invention later. By publishing it, you ensure it's not novel anymore, thereby preserving your own freedom to operate and use that invention without fear of being sued on it later. It's a way to keep the space open.
Okay, so besides legal clauses and searches, what are some practical defensive tools? If a founder gets that scary letter accusing them of infringement, What can they actually do?
Your practical defensive tools in that situation include prior art documentation. If you're accused of patent infringement, one of the strongest defenses is often to prove the patent shouldn't have been granted in the first place because the invention wasn't actually novel or was obvious. Having strong documentation of existing prior art earlier patents, publications, products that shows the alleged invention was already known can be used to invalidate the opposing patent. This is where that meticulous record keeping we discussed earlier becomes absolutely invaluable again.
Finding proof it wasn't new.
Yeah, exactly. Prove the patent is invalid. Design rounds. If you discover you might actually be infringing or are accused of it, and the claim looks potentially valid, you might be able to strategically modify your product or process to design around the specific claims of the protected IP. This means achieving a similar function or result, but without using the protected elements defined in their patent claims. This can be a very effective technical and business solution to avoid ongoing infringement.
Engineer your way out of the problem.
Sometimes, yes, licensing negotiations. And sometimes, honestly, the most pragmatic and cost-effective solution, even if you think you might have a defense, is simply to negotiate a license to use the other party's IP, rather than facing the uncertainty and massive expense of litigation. It might be cheaper in the long run to pay a reasonable royalty than to fight a protracted multi-million-dollar legal battle you might still lose.
Okay, that covers navigating conflict. Now, looking ahead, what's fascinating here is that the whole landscape of IP seems to be constantly evolving, doesn't it? Sometimes in incredibly complex ways, especially with new technologies like AI emerging at just breakneck speed. Where do you see IP heading in the next few years? What are the most significant emerging trends that startups really need to be acutely aware of as they try to build for the future?
You're absolutely right. IP is definitely not static. It's a highly dynamic field, constantly adapting or trying to adapt to major technological shifts. I think there are three major emerging trends right now. They're particularly noteworthy for their potentially profound implications for startups. They present both really exciting new opportunities and some very complex new challenges.
Okay, what's trend number one? I have a feeling I know.
You probably do. First, we have the increasingly complex and debated area of AI-generated inventions and creations. As artificial intelligence systems become more and more sophisticated, they are now capable of not just assisting humans, but in some cases, seemingly autonomously generating new inventions, writing code, creating music, designing products.
Yeah, AI doing the creative work.
Exactly. And this raises profound patentability and copyright questions. Specifically, there are huge ongoing debates globally about inventorship and ownership when AI contributes significantly, or even primarily, to an invention or creation. Current patent law in most places, for example, explicitly requires a human inventor. So what happens when the AI seems to be the inventor?
Right. So if an AI model comes up with something brilliant, who owns the IP? Can the AI itself own it? Probably not, right? Since it's not a legal person.
Correct. Under current law, an AI cannot be named as an inventor or author.
So is it the person who designed the AI, the company that owns and operates the AI model, the user who wrote the prompt that led to the creation? Or maybe even the owners of the vast amounts of data the AI was trained on? These questions must be keeping lawyers and policymakers extremely busy.
Those are precisely the thorny questions being grappled with by courts, patent offices, and legislators globally right now. And frankly, there are no easy, universally accepted answers yet. The law is lagging behind the technology here.
So what should startups using AI do in the meantime?
For startups leveraging AI, the current best practices really focus on documenting human involvement. Clearly define and meticulously document the human contributions to any AI-assisted invention or creation. Emphasize the human insight, direction, selection, and refinement involved. It's also crucial to maintain meticulous records of the AI systems used, the training data involved, and the specific prompts given. This evidence could be vital in establishing sufficient human oversight and intellectual input to potentially qualify for protection, arguing that the AI was merely a sophisticated tool used by a human inventor or author.
Frame the AI as a tool, not the creator.
That seems to be the safest approach currently. The implications for startups are significant. You need to carefully assess whether the outputs from your generative AI models actually qualify for IP protection under current human-centric laws. And you need to clarify internally and perhaps with legal counsel whether your AI is being used as a tool assisting a human creator, or if it's operating more like an autonomous creator whose outputs might, under current interpretations, fall into a legal gray area or even the public domain. The legal landscape here is still very much being shaped country by country.
Okay, AI is a big one. What's the second major trend?
Second, the complex relationship between open source software, OSS, and traditional IP continues to evolve and poses ongoing challenges, especially for software startups. Open source software governed by a wide variety of different licensing models is absolutely pervasive in modern software development. It forms the backbone of countless applications and platforms.
Everyone uses open source code now.
Pretty much everyone. Understanding the specific licenses attached to the OSS component to use common ones like GPL, General Public License, the MIT license, the Apache license, is absolutely critical. These licenses dictate what you can and cannot do with the code, whether you're obligated to share your own modifications or derivative code if you distribute your product, and what kinds of commercial use are permitted.
And some of these licenses can be quite restrictive, right? Like the copyleft ones.
Exactly. Some licenses, particularly the strong copyleft licenses like the GPL, might require you to release your own proprietary source code under the same open source terms if you distribute software that incorporates or links to their GPL licensed code in certain ways. This can be deeply problematic for startups whose core business model relies on keeping their own software proprietary.
So a startup could inadvertently find itself forced to give away its core proprietary IP if they don't fully understand the implications of the open source licenses they're incorporating. Or maybe even just don't know what open source components their developers have pulled into the product. That sounds like a huge risk, especially during due diligence.
It is a huge risk, and it comes up constantly in tech M&A and funding rounds. The key here is compliance for startups. You absolutely must implement robust open source policies within your development teams. And you need processes to diligently track all open source dependencies used in your products before release, to ensure you're complying with all the license terms and avoiding dangerous incompatibilities or obligations.
What happens if you mess this up?
Ignoring OSS compliance can lead to serious consequences. Potential copyright infringement lawsuits, being forced to disclose your valuable proprietary code, having to re-engineer your product at great expense, or even having your own IP rights potentially invalidated or clouded during an investor due diligence process or an acquisition. It's a real landmine if not managed carefully and proactively.
So how do you manage it effectively?
Startups should build compliance checklists and processes that include using automated dependency scanning tools, there are many available, to identify all the open source components and their associated likelihoods within your software code base. You need visibility. Referring to license compatibility matrices to ensure that the various different open source licenses used within your project can legally coexist without creating conflicts or unacceptable obligations, like forcing your whole project under GPL. Establishing clear contribution rules for any involvement your employees have in external open source communities. You need to manage what your team contributes back to open source projects to ensure it doesn't inadvertently expose your company's own valuable trade secrets or create unintended licensing obligations for your company.
Okay, managing open source is critical. What's the third emerging trend?
Lastly, and this one is perhaps more forward-looking but potentially transformative, we're seeing fascinating developments at the intersection of blockchain technology and IP management. Blockchain's core features its decentralized nature, its immutability, its transparency, offers some really compelling new use cases for managing IP assets that could fundamentally change how things are done.
Blockchain for IP, how would that work?
Well, potential applications include using the blockchain for decentralized timestamping of creations. You could record a hash of your invention disclosure or creative work on a blockchain to create an immutable, verifiable record of its existence at a specific point in time, which could be useful evidence for proving prior art or originality.
Like a digital notary.
Kind of, yeah. Another big area is enabling smart contracts for automated royalty payments. Imagine a system where usage of a copyrighted song or patented technology automatically triggers a royalty payment directly to the creator's digital wallet via smart contract, bypassing intermediaries and increasing transparency.
Wow, that could really disrupt royalty collection societies.
Potentially, yes. And blockchain could also facilitate transparent provenance tracking for creative works, especially digital ones like digital art or collectibles, ensuring authenticity and providing a clear, verifiable ownership history.
That sounds like it could revolutionize how IP is managed and monetized, making everything more transparent and maybe more efficient. But what are the current challenges holding back widespread adoption? It doesn't seem mainstream yet.
You're right, it's still early days, and there are significant adoption challenges. These include the need for much greater standardization across different blockchain platforms being used for IP purposes. There needs to be broader legal recognition by courts and governments for blockchain-recorded IP rights within traditional legal systems. Does a timestamp on a blockchain hold up in court as proof? And there are practical challenges in seamlessly integrating these new decentralized systems with existing centralized IP databases, like patent office records, and enforcement mechanisms. The established legal and administrative frameworks are still catching up to the potential of the technology.
There's still some hurdles to overcome.
Definitely. But despite these hurdles, innovative approaches are emerging rapidly. We're seeing experiments with the tokenization of IP rights, where fractional ownership of a patent or copyright could potentially be bought and sold as digital tokens on a blockchain, opening up completely new investment avenues for IP. We're seeing the rise of IP marketplaces utilizing NFTs, non-fungible tokens, for trading unique digital assets like digital art, music, or even virtual goods, with ownership recorded on-chain. And people are actively developing concepts for entirely transparent royalty chains that can make artist and creator payments much more equitable and efficient by automating the payment flows directly from usage data to creators' wallets. It's definitely a space ripe for disruption, and one startup should keep an eye on.
So, after all that, what does this all mean for you, the listener? We've covered a really vast landscape today, haven't we? From the absolute core definitions of intellectual property, all the way through to intricate strategies for protecting and leveraging it, the common pitfalls that can completely derail a promising startup, and even peered into the cutting edge of future IP trends like AI and blockchain.
We covered a lot of ground.
We did. And I think the takeaway is crystal clear. A really robust understanding of IP is simply indispensable for any founder, any innovator, anyone navigating the complexities of competition and growth in today's economy. It's not optional anymore.
Not if you want to build something lasting.
Right. By proactively identifying your IP, rigorously protecting it through the right mechanisms, and then strategically leveraging those assets, you can profoundly strengthen your market position, attract that essential investment you need to scale, and unlock entirely new revenue streams for your venture. It's fundamental to success.
And if we really connect this to the bigger picture, it becomes so evident that IP is not merely some legal formality you have to deal with. It is a central strategic component of your entire business plan. It's arguably the engine of sustained growth and the very bedrock of long-term success in today's innovation-driven world. That next big idea you have, it isn't just a product or a service. It's potentially a defensible, strategic asset just waiting to be nurtured, protected, and grown.
A strategic asset, that's the key mindset shift.
Exactly. So to try and crystallize our deep dive today, maybe here are 4 key takeaways for everyone listening. 1. IP is a strategic asset. Remember, it's often the most valuable asset a startup possesses. It's crucial for both your valuation and for establishing a defensible competitive advantage, that moat we talked about protecting your company.
Build the moat.
Build the moat. 2. Proactive protection is absolutely key. Don't wait until it's too late or until you have a problem. File early, especially before disclosure. Secure clear ownership through well-drafted agreements right from the start, and maintain meticulous records to avoid those costly and depressingly common pitfalls like accidental public disclosure or ownership disputes.
Get ahead of the problem.
Get ahead of them. 3. IP fuels growth and investment. A strong, well-managed IP portfolio isn't just a shield, it's also a powerful magnet for investors. It proves your market defensibility, signals your innovation leadership, and enables diverse, powerful monetization strategies beyond just selling your core product.
It attracts money and creates options.
Exactly. 4. Stay aware of emerging trends. The landscape of IP is constantly changing. Developments in AI, the nuances of open-source licensing, and the potential of blockchain are actively reshaping how IP is created, protected, valued, and managed. Staying informed requires ongoing adaptation and vigilance.
The learning never stops.
Never stops in this field. So maybe the final thought to leave you with is this. Consider how your next big idea, that thing you're passionate about building, isn't just a product or a service. Think of it as a defensible, strategic asset waiting to be nurtured and protected. So the real question is, what steps will you take, maybe even today or this week, to secure its future and transform it from just a fleeting concept into an enduring, protected asset that can drive your success?